Good. Well, we're ready to go. Hello, I'm David Anderson, and I'm here to welcome you to the second in our series of webinars on litigating abuse of a dominant position. The focus today is on pharmaceuticals, and there will be 3 more webinars in the series, the first of them next week. I hope you can see them on the screen, and I hope even more that you will be able to attend. We've divided this week's subject into 3 areas: market definition, abuse, and more specifically, the abuse of excessive pricing. And those subjects will be addressed by our 3 speakers, all of them members of Brick Court Chambers. Jemima Stratford QC on market definition. Jemima cut her teeth in pharmaceutical litigation with me many years ago, but has gone on to much greater things. She has a wealth of experience in regulatory work, and she's been acting recently in one of the CMA's excessive pricing investigations. Then David Scannell will talk about abuse. He works in all fields of competition law, including follow-on damages claims, standalone damages claims, direct appeals, CMA investigations, mergers, and state aids. And pharma regulation is a significant part also of his practice. He's appearing for GSK in the Broxton case before the CAT, and he's also a member of the Irish Bar, as indeed is Jemima, which of course means they continue to work and appear before the CJEU. Tom Pascoe, finally, has a mixed practice in competition and commercial law. He was the junior counsel for one of the pharma companies in the leading case on excessive pricing, which he is going to be talking about. We'll then have some time for questions. Hopefully you can see a Q&A box on your screen, which we would like you to use, please, for the questions. If you can't see the Q&A box, you will find it on the control panel to the side of your screen. And if you can't see the control panel, then if you click on the red box with a white arrow, then it should magically appear, and you will find within that the Q&A box. So please put any questions in the Q&A box. Speakers will go for around 15 minutes each, and we will aim to wrap up the session at 2. So without further ado, over to Jemima.
I'm going to start where abuse of dominance analysis invariably begins, with market definition. And it's trite to observe that market definition is a tool and not an end in itself. It is a building block. If we could have my first slide, please. Thanks, Paul. It's just a building block or a tool, but it's nevertheless a very important tool which can be hotly contested in abuse of dominance litigation in the pharma sector. And it's thrown up some really interesting issues in recent years. So what I want to do in the next few minutes is to flag 3 issues in this field which I think merit discussion. Before coming to my issues, the briefest of recaps of where we are and why. Of course, the market definition relates to the product, geographic, and less often to the temporal markets. The objective of defining those markets is to identify the actual competitors that are capable of constraining the commercial decisions of the undertakings concerned, such as their pricing decisions, which Tom in particular is going to talk about. And it's from this perspective that the market definition makes it possible, among other things, to calculate market shares, and that those market shares in turn convey meaningful information for the purposes of assessing market power and hence for determining dominance. With those very basic introductory observations, I'm going for most of my talk to focus particularly on the product market, which is what's recently thrown up some issues in the pharmaceutical sector. But if we could go to my next slide, please. As for the geographic market, I'm not going to spend much time on that at all, save to mention that it seems to me after Brexit, it is worth keeping an eye on how that develops vis-a-vis the UK and the EU, depending on how the new pharmaceutical regulatory landscape develops, and I suppose the trade landscape as well. Looking at it from a European perspective, of course, it's no longer the case that a centralised EU marketing authorisation extends to the UK, and only time is going to tell us whether there are any medicines where a manufacturer does not consider it commercially worthwhile to apply for a marketing authorisation in the UK market, or perhaps, maybe more realistically, to apply as soon for the UK. Even then, depending on how trade develops, it may remain the case that for at least most medicines, the market still extends to include the UK. Moving to my next slide, please, and turning to the product market, I want to come to the first of my 3 issues, which is potential competition. Now, the classic approach, most clearly perhaps set out in the Commission's 1997 Notice on Market Definition, is that the relevant product market includes products which are substitutable or sufficiently interchangeable with the products in question. This is substitutability not only in terms of their characteristics, but also in terms of the conditions of competition and the structure of supply and demand on the market in question. Now, of course, the 1997 notice is nearly 25 years old, so it's almost prehistoric in competition law terms. And as you will know, the Commission is now consulting on a revision to that notice. I looked, when preparing for this seminar, at the summary of responses to the consultation prepared in December of last year. It refers to the fact that some respondents pointed to pharmaceuticals as a sector that needs specific attention in the market definition context. Most attention of all, unsurprisingly, is given in the responses to digital markets, which, as David mentioned, is going to be the subject of our next seminar. But pharmaceuticals and the life sciences sector generally is also remarked on as an area that merits some special thought. And I think that's absolutely right, because in at least one notable respect, the way in which the case law has developed in pharmaceutical abuse cases is contrary to what's said in the Commission notice. Because at paragraph 24, the notice states, and I'm going to read part of it out, but you've got the full quote on the slide. If you can read that, I hope it's not too small. It says, potential competition is not taken into account when defining markets, since the conditions under which potential competition will actually represent an effective competitive constraint depend on the analysis of specific factors and circumstances related to the conditions of entry. If required, this analysis is only carried out at a subsequent stage. And then you can see the rest of the sentence. And yet, so that's pretty clear. But again, as most people on this seminar will know, in the ruling of the Court of Justice in the GSK case, that's case C 307/18, the court answered the question on market definition, which had been referred by the CAT, by saying that as long as generic competitors have made preparation such that they're in a position to enter with sufficient strength, they exercise a competitive constraint that should be taken into account in market definition. And David is going to talk later in this session in more detail about GSK, or Generics UK, as it's also known. But as you will recall, it concerned the antidepressant paroxetine and a finding that GSK had abused its dominant position by making cash payments and other value transfers to induce generic potential competitors to delay their potential entry into the UK paroxetine market. So it's a pay for delay case. Now, I've seen a suggestion in the academic commentary on that case that even the Court of Justice's approach is too generous, approach to market definition is too generous to a company such as GSK. The Court of Justice held that it is necessary to assess whether the manufacturer of generic medicines concerned has a firm intention and an inherent ability to enter the market, having regard to the preparatory steps it has taken, and that there are no insurmountable barriers to entry. Importantly, any patent rights do not constitute in themselves such barriers, according to the court, since their validity can be contested, as it's put, which means litigated and argued about. Now, to the eyes of most IP lawyers that I've spoken to, this is already pretty strong stuff. Yet, as I mentioned, some commentators suggest that the court should go even further and should hold that even where entry by generics is not imminent, it should be taken into account as a competitive constraint. And if you're interested in this topic, there is a short article by the economists Nevin and Siotis, which proposes this view. But I must say, I find that difficult to follow. I'd be interested to hear in the discussion from anyone who does agree with this. But it seems to me that surely the generics at least need to be knocking on the door. They need to be realistically able to enter the market before they can constitute a competitive constraint. And some would argue that the Court of Justice has already gone too far. Certainly, I know from IP lawyers and patent attorneys that I've spoken to that they regard the approach of the competition courts to be somewhat puzzling, since in particular, from their perspective, it seems to pay little regard to whether a patent has been held to be valid and infringed, and therefore whether the generics could ever lawfully enter the market. Next slide, please. Turning to my second issue, this arises particularly clearly from the decision of the General Court in the Servier case. The judgment in that case shows the importance and indeed the difficulty of defining the relevant market in pharmaceutical cases. The case, again, very brief recap, it concerns the heart drug. It concerned the heart drug perindopril. It made it clear that such market definition, as occurs, must be based on thorough analysis that takes into consideration the overall regulatory, therapeutic, and economic context. Now, when determining therapeutic substitutability between pharmaceutical products, and hence whether they may belong to the same product market, competition authorities often include use of the anatomical therapeutic chemical classification system, known for short as the ATC system. This divides medicines into different groups according to the organ or system on which they act and their chemical, pharmacological, and therapeutic properties. Very briefly, and I've put this on the slide, ATC 3 level comprises all pharmaceutical products with the same therapeutic indications. So all pharmaceutical products that are used to treat the same indication. or same problem, if you like. ATC4 constitutes a further subdivision based on therapeutic and pharmacological criteria, such as molecule class, formulation, or mode of action, while ATC5 level is narrower still, and it's limited only to individual active substances. So really at ATC5 level, you're talking about molecular identicality. In Servier, the Commission had defined the relevant market on the basis of that ATC5 level, and so had limited it to perindopril, both patent protected and generic. The General Court noted that even though this choice wasn't criticised per se, all other 16 ACE inhibitors were grouped under ATC3 or ATC4 level, while according to published medical research, perindopril did not differ therapeutically from those other ACE inhibitors in terms of efficacy. And as a result, the court held that the Commission had erred in finding that perindopril was heterogeneous and had particular characteristics with regard to its therapeutic usage, while it also rejected the finding of the inertia, what was termed the inertia mechanism of doctors that allegedly restrained the competitive pressure exercised on perindopril from other pharmaceutical products. In addition, the court found that the Commission had underestimated the patient's inclination to change treatment, and held that the Commission didn't properly take into consideration the promotional efforts of other companies and their importance when analysing competitive relationships. Finally, on this, the court noted that the Commission had misunderstood the particular characteristics of competition in the pharmaceutical markets by finding that perindopril was not subject to significant competitive pressures from other ACE inhibitors. All of this unsurprisingly led the court to conclude that the Commission had failed to establish that the relevant market was limited to the perindopril molecule only. And as a result, and since the product market was erroneously defined, the calculation of the market shares by the Commission was also overturned. The court found that whatever the relevant geographic market, Servier's perindopril was never in a dominant position amongst ACE inhibitors in terms of sales within the time period examined in the Commission's decision. And accordingly, the court reversed the Commission's finding of an abuse of dominant position and annulled that part of the fine imposed. Now, of course, we wait to see what the Court of Justice says about this on appeal. But for now, I think we can observe with reasonable confidence that the case shows the importance of a concrete economic analysis when defining the relevant pharmaceutical market. So ATC levels may serve as a helpful starting point in the definition of relevant market, but are not an end point, I suggest. There are a number of potential factors that can affect a drug's market definition. Furthermore, it would be dangerous, in my view, to take from Servier that a competition regulator or court will always accept that patients and doctors are prepared to switch to different medicines and different active ingredients. This is an area where such decisions are intensely fact-sensitive. And moving swiftly to the next slide, I'm conscious of time, I don't think we should just dismiss as outdated the approach of the same court in AstraZeneca, where considerable emphasis was placed on the reluctance of doctors and patients to switch medicines. That was drugs used to treat gastrointestinal acid-related conditions. Indeed, there are some medicines where changes even at molecular level are of real therapeutic significance. For example, I'm aware from cases I've done, different enantiomers of the same active ingredient may have important therapeutic differences. One can imagine there may be, for example, some pharmaceutical forms or routes of administration which may have a particular hold in some geographic markets for whatever reason. And those are just examples of the myriad of issues which I suggest may arise. All of this serves to show that the contextual and fact-specific nature of market definition means that the way a relevant market was defined in a previous case is not legally binding. And I've given you the cases that establish that. So market definition is to a considerable extent judgmental, and you may say bliss, therefore, for lawyers, economists, and other experts, but hardly helpful for clients and legal certainty. And that brings me on to my third issue and the final slide, please, and the reality of what some of these recent developments in the case law are doing to litigation in the pharma sector. It's not that rare that I'm sitting at my desk and the phone rings or an email pops up asking for urgent advice on a proposed settlement in patent litigation from a competition law perspective. And it's genuinely fraught with difficulty how safely to settle such litigation now without risking competition law consequences. David Scannell is going to say a little more about that, but for now I just note that given recent case law, it's rarely going to be safe to assume that the market is wider than the medicine in issue. For obvious reasons of confidentiality, it's difficult to talk concretely about settlements, but I just wanted to note that settlement is definitely more difficult, and that must surely raise wider issues of public policy about the desirability of settlement versus the desirability of patent litigation being ventilated openly in the courts. It does raise other questions too, and I just put those on the slide to leave them with you. Are competition authorities and courts stretching the intellectual parameters of market definition to achieve their end goal? And if so, what are the ramifications of that? Second, does it make sense that originators face an increased risk of being found dominant at exactly the point in time they're losing exclusivity and facing competition from generics? Third, and more generally, is competition law being asked to do too much and to perform roles that are better performed by the regulatory system? And with that, and apologies for running slightly over, I will leave it there. Thank you.
Jemima, thank you very much indeed. We've started to see questions coming through on the Q&A, which is to be found on your control panel. Do keep them coming, and we'll go straight on to David Scannell, who's going to talk to us about abuse.
Thank you very much, David and Jemima. If we could have the first of my slides, please. The focus of my remarks will be on the CAT's pre-reference judgment in paroxetine, given as far back now as March 2018, so far as that judgment relates to abuse, and to the preliminary ruling given by the Court of Justice in January last year. And I've set out the references on that slide. Before I turn to those points, I'd like to add, if I may, some very brief remarks to Jemima's very interesting remarks on market definition in the specific context of the paroxetine case. As Jemima has suggested, the Court of Justice's judgment in paroxetine on market definition represented a significant departure, arguably, from the traditional principles of market def in the pharmaceutical space. And it does so, to my mind at least, in two respects. First, that it involves taking account of the nature of the abuse in defining the relevant market. And second, as Jemima has explained, it entails the possibility of including in the definition of the relevant market generic products which are not yet on that market. They are vying to enter, but they have not yet established a right to enter, and they may not have a right to enter That is all to play for in the patent litigation. In the pre-reference judgment of the Competition Appeal Tribunal, the CAT fairly acknowledged that the adoption of an approach along those lines would be novel. Indeed, it gave a strong indication in its pre-reference judgment that if conventional principles involving therapeutic substitutability, the ATC classes that Jemima has spoken of in the context of Servier, and shocks analysis based on genericization of the market over time and market entry by different products were to be adopted, GSK might very well succeed in establishing that it's not dominant on the relevant market. The point I would like to emphasize in relation to all of this is that the market definition question that the CAT sent to the Court of Justice was all about whether it was permissible to take into consideration generic products which are vying to enter the market when the originator's product patent has expired and it's relying on a process patent, the validity of which is disputed, and where that dispute is gotten rid of through the settlement agreement. The answer that the court has given to the Competition Appeal Tribunal is that it is possible to take account of those generic products vying to enter the market, so long as, Jemima has explained, as those generic products impose sufficiently strong competitive constraints on the behavior of the originator on the market. So, in other words, the court has answered the CAT's question by saying, yes, it may be possible in the right circumstances to take account of generic products that are not yet on the market. The question that's left hanging after all of that, though, is whether the inclusion of those generic products in the relevant market means that the therapeutically substitutable medicines, which are already on the market, somehow get airbrushed out of the picture. In the pre-reference judgment of the Competition Appeal Tribunal, the CAT held that GSK had established that there were any number of other SSRIs, that's to say selective serotonin reuptake inhibitors, on the market, along with other antidepressant medications that were therapeutically substitutable with Soroxat, and moreover that they impose competitive constraints on GSK's market behavior. However, what the CAT said was that that was not the competitive constraint that had motivated the particular form of abuse. The competitive constraint that had motivated entry into the settlement agreement was the competitive constraint presented by the generics trying to enter the market. Curiously, the Competition Appeal Tribunal didn't ask the question whether taking account of the abuse allowed it to exclude the competitive constraints presented by the therapeutically substitutable drugs. And the striking nature of the omission of a question to the Court of Justice on that particular question is rendered all the more striking, I would suggest, by the Competition Appeal Tribunal's acknowledgement in its pre-reference judgment that if it were right that the only products that get taken into account on market definition in a case like this are the originator's product and generic versions of the originator's active ingredient, then this would lead to a curious and troubling result. It would mean, and these are the CAT's words, not mine, that almost every valuable medicine which was subject to patent protection, but which eventually attracted generic entry once the patent expired, would constitute a distinct market, with the consequence that the patent holder was therefore dominant in that market. We agree that this would be a material change to the IP bargain, and one that might adversely affect the economic purpose of the patent legislation. I would respectfully suggest that therapeutic substitutability still has an important role to play in market definition in the pharmaceutical sphere. How important that role is will turn on the factual assessment of the degree of competitive constraint imposed by the therapeutically substitutable products. But so long as they are sufficiently strong, I would suggest that they not only should, but must be included in the relevant product market, even if one is also including generic versions of the originator's product. Turning then to abuse, and I'll very quickly begin by going through the basics, which I'd propose to do in 3 steps, if we could have the next slide. The first is that the concept of abuse has been defined as an objective concept. It focuses on whether the behavior of a dominant undertaking, and of course the fact that there is a dominant undertaking at all suggests that competition on the market is already depressed to an extent, whether that behavior influences the structure of the market, and whether the undertaking has had recourse to methods different from those which condition normal competition between commercial actors, with the effect that competition remaining on the relevant market is restricted. And I've given some references to the key cases, repeating that test for abuse on the slide. Turning to the next slide, a typology of forms of abuse, of course, is to be found in Section 18.2 of the 1998 Act and in Article 102, but these are not exhaustive. As the Court of Appeal put it in National Grid, each case is highly fact-sensitive and dependent on an evaluation of a wide range of factors. In the early case law, the approach to determining whether particular conduct constituted abuse didn't go much further than an attempt to pigeonhole the conduct into one of the statutory forms of abusive conduct. But that pigeonholing approach has now receded. In the European Union, cases like Tomra Systems and Post-Denmark 2 heralded a more sophisticated effects-based approach. And that approach has been taken up by our courts in cases like Purple Parking, and more recently by Mr. Justice Roth in Google and Street Map. Under the more modern effects-based test, the inquiry is whether, having regard to all the circumstances of the case, the conduct is reasonably likely to restrict competition. And finally, on the basics, the dominant undertaking may seek to justify a behavior that would otherwise constitute an abuse. It can demonstrate in particular that the conduct is objectively necessary, or that the exclusionary effect produced by the conduct is counterbalanced by efficiency gains which benefit consumers. Turning to the next slide, in paroxetine, the CMA's case on abuse tracked to some degree its case on restriction by object. The conduct that was said to be abusive was identified as entry into settlement agreements, and the effects on competition were defined largely by reference to those settlement agreements. A strategy of monitoring and managing attempts by generics to enter the market was referenced in the decision, but the competition effects specifically attributable to the strategy above and beyond the agreements didn't feature in the decision. In paragraph 410 of the CAT's judgment, the CAT accepted that the CMA's case hinged in large part on success on the Chapter 1 case, at least so far as concerned the 2 settlement agreements that were challenged under Chapter 1. There was a third agreement. It was in fact the first settlement agreement in time that was concluded. That was not challenged under Chapter 1, but it was part of the Chapter 2 case. And that agreement, the agreement concluded with IVAX, was significant because it brought about quite significant efficiency gains. It provided for the supply of paroxetine to the generic IVAX, and that supply caused the reclassification of paroxetine under the NHS's drug tariff, meaning lower reimbursement prices for the NHS to pay. The CAT did wonder in its pre-reference judgment whether that efficiency gain was something that had to be taken into account, or whether it's something that could be excluded from account on the basis that it wasn't subjectively intended by the parties to the settlement agreement, although it accepted that they would have been aware that that reclassification was a likely consequence of entering into the agreement. On the next slide, I set out the questions on abuse that were sent by the CAT to the Court of Justice, and those questions reflected the way the CMA had framed its decision and consequently how the case had been fought in the Competition Appeal Tribunal. Multiple questions were asked, as you can see. The central focus of them was whether abuse would be made out if it were found that the settlement agreements were restrictive by object. The Court of Justice, as it often does, showed no interest in many of those questions. What it focused in on was the question that I've highlighted on the slide, which focused on whether an abuse can be made out where a dominant undertaking with a process patent, but whose product patent has expired, has a strategy of concluding settlement agreements with generics, which have the effect of temporarily keeping them off the market. On the next slide, the key paragraph of the court's ruling on this question is paragraph 172. The court said that the strategy of a dominant originator, which leads it to conclude settlement agreements which have the effect of keeping generic medicines temporarily off the market, does constitute an abuse, provided that that strategy has the capacity to restrict competition, and in particular, to have exclusionary effects going beyond the specific anti-competitive effects of each of the settlement agreements that are part of the strategy. And it's for the national court to determine those questions. The court added that the assessment of objective justification requires the court to conduct an objective effects analysis. And within that objective analysis, efficiency gains have to be taken into account, whether they're intended or not. So the court did not accept that the benefits to the NHS of the first settlement agreement could be disregarded. The ruling on abuse creates an interesting challenge for the Competition Appeal Tribunal. The test espoused by the court calls for a distinct assessment of effects of the patent holder's patent strategy on the relevant market. And it must be shown by the regulator that those effects are greater than the sum of the negative effects of each of the settlement agreements that are concluded pursuant to that strategy. As I explained a moment ago, that approach wasn't readily discernible from the CMA's decision. The Court of Justice arguably helped the CMA a little in this respect at paragraph 157 of the ruling by suggesting that a contract-oriented strategy is liable to exceed the anti-competitive effects caused by the conclusion of the agreements that are part of it. But the problem, I'd suggest, with that observation on the facts of the generics case is that no finding has been made by the CAT that the strategy in question was a contract-oriented one. The finding that has been made by the CAT to date in the pre-reference judgment is that the relevant patent strategy embraced the possibility not only of settlements, but also of litigation without settlement all the way to judgment and beyond. The CAT couldn't realistically go any further than that because GSK had in fact litigated against multiple generics trying to enter the market without settling with them. In the Apotex litigation, for instance, the case was litigated all the way to the Court of Appeal, and GSK indeed won that case in the Court of Appeal in establishing that the relevant claims under its anhydrate patent were valid, albeit not on the facts of that case infringed. So it will be interesting to see how the tribunal resolves the abuse element of the GSK case when it gives its final judgment, which is due, I should have said at the outset, at the end of this month. Before I finish, if I could just make one final, very quick point. In the first of the Brick Court Chambers seminars on Chapter 2, the suggestion was made that the court should now possibly embrace the concept of an abuse of a dominant position by object. That's to say where the conduct of the dominant undertaking is such that it is known to be so likely to be harmful to competition that it's unnecessary to assess what the actual effects of that conduct were. The Court of Justice has, of course, already come very, very close indeed to recognising a concept of abuse by object in cases like Pascoe in 1991, where it said that pricing below average variable costs must be regarded as abusive because it must be motivated by a desire on the part of the dominant undertaking to eliminate competition and then exploit the monopolistic position it is left in by increasing prices. In the same case, it said that pricing below total costs but above average variable costs must also be abusive if it's designed to eliminate a competitor. Similarly, in Intel, more recently in 2014, the court said that exclusivity rebates granted by dominant undertakings are by their very nature capable of restricting competition. And it's certainly not difficult to see examples which might lend themselves to an abuse by object analysis. Recently, we had the Lithuanian Railways case at the end of last year, where the facts were that Lithuanian Railways had sought to punish one of its customers for discontinuing its service in transporting its oil from Lithuania to Latvia. And the way it went about punishing that customer was simply digging up 19 kilometers of its own railway track. And to bring things back to the competition domain, one wouldn't be surprised to see a by-object analysis in a case like AstraZeneca, which was referred to by Jemima. The very short point I'd make in relation to all of that is that I've seen it suggested that the court in paroxetine was acknowledging some sort of abuse by object. That's not a view I would subscribe to. I think it's tolerably clear that an effects analysis is necessary in respect of the strategy and the settlement agreement. Thank you.
Thank you very much, David. I pity any court or tribunal that had to wrestle with that preliminary ruling, and I look forward to seeing the outcome. Tom, we'll go straight out to you.
Thank you, David. I'm going to speak about excessive pricing in the pharmaceutical sector. If we could perhaps start with my first slide, please. It's fair to say that excessive pricing until recently has arisen in a few isolated pockets like French funerals, English horse racing data, Latvian music licensing, but on each occasion it's popped up and then sort of disappeared back into obscurity again. But that's all changed with the advent of a whole slew of new excessive pricing investigations into pharmaceutical products. And those investigations have forced regulators and, in some cases, courts to consider the very tricky question of what is a fair or an unfair price for a medicine with potentially life-changing or even life-saving qualities. Now, even saying that question out loud raises the obvious issue of whether competition regulators or courts are best placed to answer it. But that is precisely what they've been called upon to do in this most recent series of investigations. Now, you can see from the slide I've picked out 5 particular investigations. They date back all the way to mid-2013, and perhaps of particular topical interest is the very recent investigation into hand sanitizer products during the first COVID lockdown that opened and closed relatively quickly. But say perhaps for that special case, a common theme of all of the investigations is that they concern medicine that was at one point sold at a relatively low price and was then subject to a fairly sudden price increase. And I'm going to focus on just 2 of them. The first being the Fenetone case, because that it is the only case to have reached the courts, and the second, the Aspen Commission decision, because that is hot off the press as of last week. So I'd like to start with Fenetone, if we could turn over the slide, please. Now, with apologies for those who are very familiar with the case, I'm going to set out the background in just 4 short facts. The first is that phenetoin sodium is a relatively old drug from the 1930s that's used to treat epilepsy, and it has what's called a narrow therapeutic index, which means there is clinical guidance which at least limits patient switching between one manufacturer's version of the drug and another manufacturer's version, even if they are therapeutically and identical at the molecular level. Before 2012, phenetone was sold by Pfizer as a branded drug, essentially for pennies, and it's Pfizer's case at a loss, under a price regulation scheme called the PPRS. The drug was then acquired by Flynn in 2012, and as a result of that, it was released from the PPRS, and the prices increased. And if we could have the next slide, please, that reproduces the price increases that were set out in the judgment that I'll come to. But a key feature of the case is that these new prices were not just plucked out of the air. They were benchmarked to the price of another product already on the market, the tablet formulation of precisely the same drug, which was marketed primarily by Teva. Now, the CMA opened its investigation into these price increases in 2013 and finally published a decision in 2016, finding that both Pfizer and Flynn had charged excessive prices. The decision imposed a record-breaking fine of £85 million on Pfizer and a penalty of £5 million on Flynn. If we could have the next slide, please. Now, the decision itself ran to several hundred pages and is very long and complex. I'd like to just pick out a few key features. The first is that the CMA thought that the right approach to assessing whether Pfizer's and Flynn's prices were excessive was what's called a cost-plus approach. So you essentially look at how much it costs to supply the medicine, you add a reasonable rate of return, and that is your fair or benchmark price. Now, secondly, the CMA found that the reasonable rate of return for a drug like phenetone was 6%. That 6% figure came from the very PPRS scheme that phenetone had been taken out of when it was acquired by Flynn. But perhaps most importantly, was said by the CMA to be backed up by economic theory as being a price, a minimum price, which a pharmaceutical company could charge under conditions of perfect competition that would still incentivize them to remain in the market. The other major aspect of the decision is that the CMA considered it was not necessary to conduct a full examination into the price of the existing Teva tablet on the market, because it considered, as a matter of law, that Pfizer's and Flynn's prices were unfair in themselves, and it was therefore not also necessary to prove that they were unfair when compared to other products. If I could have the next slide, please, Paul. Now, the Competition Appeal Tribunal, in a ruling now a couple of years ago, held that the CMA had got this part of its decision fundamentally wrong. In particular, it thought that the CMA had taken a wrong turn when it sought to construct an economic theory about what the price of the drug should have been in order to incentivize Pfizer and Flynn to stay in the market, rather than what prices on the market actually were for other types of similar products. If we could just turn the page, please. I've set out here essentially the approach that the tribunal envisaged, which is that you have a shopping basket of all sorts of different comparator figures. That might include very close comparators like the biologically identical Teva tablet, and it might include other types of comparators, such as how profitable Pfizer's and Flynn's other products are, how expensive other anti-epileptic drugs are, and how profitable companies such as Pfizer and Flynn are generally. And you put them all into the basket and weight them according to the relevance of the comparison or the closeness of the comparison. And you mix them all together and you come out with what the tribunal referred to as a normal competitive price. So coming back to the question that I opened with, what is a fair or an unfair price for a potentially life-altering medicine? The tribunal said you look for empirical evidence about the actual prices of other medicines on the market rather than to economic theory. Now, I should say there was an appeal from the CAT's decision. The Court of Appeal, with some nuances, essentially upheld the CAT's approach and remitted the investigation to the CMA, where it is still currently sitting. If we could have the next slide, please. The one other aspect of the CAT's judgment, which I think is interesting and I'd like to focus on, is its treatment of economic value. Now, economic value is part of the test for excessive pricing because it's necessary to show that the price of the product is higher than its economic value. The CMA analysed the situation like this. They said that there comes a point at which the user of a product is so dependent on it that the economic value of that product to the user has to be counted as nil, because essentially the user, or the patient in this case, has no choice but to buy it. Now, interestingly, the CAT was not on board with that approach. They said that the demand side value of a product, so in a pharmaceutical case, the value of the product to the patient doesn't just fall off a cliff edge because the patient is dependent on it. And what the tribunal said is that placing a precise monetary value on patient benefit is not straightforward, but it appears to us that a qualitative assessment would be possible and should have been attempted by the CMA rather than simply assessing the value as nil. So it will be interesting to see how the CMA deals with this question of putting a figure on the value of life-changing or life-saving medicines to patients in its pipeline of investigations that are ongoing. If I could have the next slide, please. The point that I wanted to end on is the Commission's decision in the Aspen case. This is hot off the press. It was published just a couple of weeks ago. The decision concerned 6 old cancer drugs, and in a sense it's of a piece with the other pipeline of pharma investigations, in the sense that the drugs were acquired from another company, in this case GSK, and there was then a price hike. Now, what I think is particularly interesting about the Commission's decision is that it essentially adopts the approach advocated by the CAT and the Court of Appeal in this jurisdiction. You can see from the quote at the second bullet point of my slide, what they did is they went out into the real world and asked how profitable are other companies in similar situations to Aspen? And is the profitability of these 6 cancer drugs significantly in excess of that? The Commission found that the median gross margin of similar generic drug companies was 54%, and their median EBITDA was 23%. And I mean, that contrasts very starkly to the CMA's conclusion in Fenetone that a reasonable rate of return on a generic drug such as Fenetone should be 6%. And one might speculate that that is the difference between asking an economist what is the minimum possible price that could be charged for this drug to keep it on the market, versus asking a statistician what prices are actually charged for these drugs and what returns are actually earned on them. So ultimately, the Commission found that these 6 cancer drugs did significantly, the profitability of those drugs did significantly exceed the sort of median profitability on the market, and accepted undertakings that the prices would be reduced. But it's an interesting decision because it is essentially of a piece with the approach adopted by the courts in this jurisdiction. So just to go to my final slide, I end on the question that I opened with: how do you decide what is a fair or an unfair price for a life-changing drug? And it seems that the answer is travelling in one direction. You ask somebody in the industry what prices are actually charged for drugs like this in the real world and what profits are actually made. You don't ask an economist, as a matter of theory, what prices should be charged. Thanks very much.
Well, Tom, thank you very much indeed. I should have mentioned, of course, that you're counsel in the Fenetone case, so you spoke about that with particular authority. We've had one question in. It's a simple, perhaps deceptively simple question. I did wonder whether it was a mischievous question, but let me read it out anyway and see whether any of you has any comment in the 2 or 3 minutes that we have left. Which of the competition regimes, EU or UK, is best able to regulate agreements that affect trade between the UK and the EU, given that Articles 101 and 102 are only concerned with effects on trade between member states? And I would have thought the EU system has certain rather obvious advantages, but there may be features of our own system as it develops that are worth highlighting as in some ways superior. Jemima, David, Tom, any very quick remarks before we bring things to a close?
The one point I would make in relation to this, David, is that when it comes, I would agree with the instinctive response that there are obvious advantages to the EU system, and obviously if the issue is whether a particular type of conduct has affected trade between member states, then that is exactly what EU law is concerned to establish. And so instinctively, one would say that the EU system is the better system. But really, I suppose what this question is aiming at is, what if I have a case and I see conduct on the UK market, and I'm interested in bringing some sort of damages claim, whether it's by way of follow-on or standalone, as seems more likely. Which species of law should I then be relying on? Well, the answer then is very different. And I do think that our system will develop in a slightly different way over time, despite what we now have in the Competition Act in Section 58A and Section 60A of the Competition Act. I think that one of the great advantages of our system is that, unlike the EU system, our cases are based on live evidence with cross-examination of witnesses, which can often provide useful pegs to hang the sort of litigation that the questioner might have in mind on. And so I can see that forensically, it may be preferable to keep things domestic.
David. Thank you very much indeed. Thank you to all the panelists. I know we're silently applauding, and thanks particularly to all of you for turning up and for staying, as the attendance figures demonstrate that you've done. Abuse might be a big subject in the pharmaceutical sector, but it's even bigger in terms of big tech, and that is the next webinar in this series, which from memory is next Wednesday. Someone will tell me if I've got that wrong. I don't have the date in front of me, but it's next week anyway. I'm not hearing a counteroffer, so tune in again on Wednesday for abuse of dominance cases in big tech. Thank you very much for attending, and we'll hope to see you then. Bye-bye.